Um, Hang on, I seem to still be experiencing a little bit of technical difficulty. Elena, can you verify if you see the screen?
I can see your screen, yes.
Okay, good.
Okay. And I'm sorry, Paul, I meant to just mention to the audience that we will be taking time throughout your presentation to pause and answer some questions. And what we will do is if anyone who has a question can type in their question in the chat area, then when we do take those pauses, I will go ahead and read some of the questions to you and answer them. And we'll
Sounds
definitely
good.
get to as many as we can. Okay. Thanks, Paul.
No problem. Thank you.
Mm-hmm.
All right, let me get this back up again. There we go. All right, I'm not the best at PowerPoint, so we're kind of muddling through here. Thanks for coming out, everybody. Feel free to get yourself a cup of coffee and some refreshments at the back of the room that I laid out for you. Oh, wait a minute. That's not going to work. Here we go. Let's try this again. There we go. I'm Paul Prior with a very unfortunately named firm of Hinkle, Fingles Prior, and we're here tonight to talk about guardianship and estate planning. That's the Hinkle and the Fingles and the Prior of the bunch. For those of you who don't know me or haven't seen me present before, I'm the shiny-headed one to the right. Of the three of us, probably the best-looking one, but I guess it's fair to say that I don't really have that stiff a competition. We're here to talk about guardianship and estate planning for an individual with an autism spectrum disorder, or really anybody who has a significant disability which interferes with their ability to make decisions for themselves and may need a protective arrangement to help them exercise their rights. As Elena said, I do want to try and take some questions as we proceed through this webinar this evening. At various points, I'll stop along the way and field some representative questions, so feel free to type your questions and send them in. And we'll try to get to as many of them as we can, although in these formats it's not always the easiest, and so we'll just try and take a representative sampling of what we got. So what I'd like to start out with, at least the beginning, is a little overview of guardianship, what that means, what it entails, how the process works, and then we'll kind of move into the wills and trusts and special needs trusts and so forth after that. So guardianship. Guardianship, when you have a child with autism, regardless of his or her age, you do want to begin at some point sooner than later to think about whether a guardianship is going to be necessary. An individual who is under the age of 18, whether or not he has a significant disability, a profound disability, or no disability, is not, in the eyes of the law, is not able to make decisions for him or herself. And parents are charged with the authority, the natural and legal authority, to make decisions on behalf of that child. When that child turns 18, again, regardless of his or her abilities or limitations, whether that's an individual with no disability or whether that's an individual with a profound disability, that kid is now an adult in the eyes of the law. And he or she is presumed to be able to make decisions on his own. Or she is determined to be an adult in the eyes of the law, and the parent's ability to make decisions for that now adult child transfers to the adult child. This includes educational decisions, being involved in the IEP process, medical decisions, financial decisions, you name it. When the child turns 18, all of his or her decision-making authority moves to now the adult child. And I don't want to necessarily frighten anybody or scare anybody into thinking that the world's going to end when the child turns 18. My experience is particularly when the child exhibits a very obvious disability, that the world will sort of look to the parents as, quote, the natural guardian, for some period of time. Very rarely are you really going to be given a hard time, particularly shortly after the child's 18th birthday. And that's true right up until the time until you get into a dispute or a disagreement from the person on the other side of the table from you. And it goes from, we know you're not the guardian, but, we want you to be involved and want you to be part of the decision-making process, to when you start to say, well, wait a minute, I'm not sure I'm really in full agreement with whatever it is we're talking about. The person on the side of the table from you goes from, well, please be involved, to who the heck are you? We're going to go ask your son what his preferences are, and you can leave the meeting now or whatever. This is particularly true if you're going to have if you've had a historically contentious relationship with your local school district, or you anticipate that it's going to be a contentious IEP meeting coming up, or whatever the case might be. You want to make sure that you are given and do have some legitimate legal authority to make decisions on behalf of your son or daughter. So a guardianship really is a protective arrangement under the law which allows one person to make decisions for the benefit of another person when that individual can't make decisions for himself. And there are a variety of protective arrangements which we're going to talk about as part of this, but guardianship is the main form. Many adults with disabilities are able to make decisions for themselves and don't require a full guardian, and in some cases, although less common, may not require any protective arrangement at all. But certainly there are a number of individuals out there that may need a full guardian. There are some individuals out there that may need a lesser form of guardianship, and some people may not need any form of assistance whatsoever. A guardian should be considered whenever you learn that there's a diagnosis of an autism spectrum disorder. A guardian should be considered for that person in anticipation that he may not be able to make decisions for himself. The legal standard for the determination of whether a person needs a guardian is whether that person is able to govern himself and manage his own affairs. And by that we mean independently. So you have to put yourself in a world that does not exist. If your kid is coming up, getting closer to his 18th birthday, put yourself in a world that doesn't exist, and imagine that child in a world where there are no natural, familial, or professionally provided supports. And ask yourself, is that child going to be able to make decisions for him or herself? Is that person going to be able to access their own medical care and seek medical attention? Is that person going to be able to make financial decisions on his or her own? Is that person going to be able to make legal decisions? Is the person going to be able to not only find a job, are they going to be able to know how to go about getting a job? Are they going to be able to know about getting a place to live, an apartment? Are they going to know to look online or get a local newspaper and look in the back in the classifieds for an apartment for rent? Are they going to be able to understand what that means? Are they going to be able to understand what a lease entails and the financial obligations thereof? Are they going to be able to attend to their own ADL skills, their own activities of daily living? Bathing, brushing their teeth, and dressing and whatnot. And again, you have to kind of look at the world in an unvarnished, or this world in an unvarnished way. Oftentimes I get parents who come in and they tell me, oh yeah, my son can shower independently and brush his teeth independently and so forth. But when you peel the onion back a little bit, you learn that they can do all these things independently, but they need to be reminded, or they need to be prompted, or whatever, while they're performing a function. So, sometimes, John can take a shower if someone reminds him to say, hey, John, time for you to go take a shower now. Or sometimes if Sue's in the shower, someone needs a reminder to, put shampoo in her hair and rinse the shampoo out of her hair, or, remind whomever to get out of the shower after like an hour and a half of being in the shower. Sometimes they need just prompts and reminders to move along. And then certainly, your more planned or abstract or executive functioning activities might need some oversight and assistance. So, can John prepare his own basic meal of a sandwich or whatever, or a can of soup, or whatever the case might be? Maybe they can. But when he runs out of food in his pantry, is he going to be able to go through the planned and executive functioning skills necessary to create a list of items needed at the grocery store, get himself to the grocery store, pick out the appropriate provisions, for the coming week or the month or whatever it might be? He's going to be able to budget for these things. He's going to be able to budget for these items and still budget for his other needs of shelter and utilities and so on. And what we find in those instances is that many people with developmental disabilities are not going to be able to do these things independently, and and perhaps never will be able to do these things independently. So, considering whether an individual needs a guardian isn't necessarily the most pleasant thing to have to think about, but it's one of the most necessary things to have to think about, because you certainly don't want to find your child in a situation where he could be easily economically exploited or taken advantage of legally by designing persons, or get himself into situations where he maybe overextends himself or gets himself into a situation he can't get out of, like a contract or similar issue. So if in considering those items you think that your son or daughter may not be able to do those things I just described in a truly independent fashion, then it really may be necessary to seriously consider whether a guardian is necessary. Now, in terms of, again, the analysis of a guardianship, as I said before, we get into the court, and this is a court process, and I'll talk about the process in a couple seconds here. The court gets into really a two-pronged analysis. One, is the individual able to manage himself and govern himself, manage his affairs and govern himself independently? And then if not, then the second part of the analysis is who should the guardian be? Now, guardians are typically one or both parents, and the parents often serve together as co-guardians. So, you have mom and dad, and you have, a minor child with or without disabilities. Your mom and dad are the co-guardians of that minor child. And then when the child with a disability becomes 18 and the court determines that the parents should serve as co-guardians, those parents basically continue on to serve as guardians in the same capacity as they did before. So basically this is a legally approved mechanism by which parents continue to have all the legal rights to be parents that they have been for the last 18 years. As parents age, or if parents are otherwise unable or unavailable to serve as guardian, if able, typically developing siblings are sometimes added on as co-guardians with the parents, or if parents die or are otherwise not available, the sibling serves as the sole guardian. And you could have more than one sibling serve as co-guardians. It's certainly not unheard of if you have more than one child who's typically developing. Maybe to have two of those typically developing siblings serve as co-guardians. If you have many children, if you have multiple children, 3, 4, 5 kids who are typically developing one child with autism, it's very unlikely the court is going to want to or allow all of them to serve as co-guardians together. The court definitely does not want to get into a situation where you have guardianship by committee and therefore perhaps nothing gets done. So as parents, it's usually a good idea to pick one or perhaps two of your, if you've got them, typically developing siblings to serve as guardian or co-guardian. And then maybe, you have a situation where you have, This is not uncommon in my experience where families want their oldest child, typically developing child, to serve as guardian, and then if that person can't serve, name another one as an alternate or a backup. And then in instances where you don't have typically developing siblings of the child with a disability, you may have to look towards other more distant family members in the family tree to serve as guardian after parents are gone or as parents age. Nieces and nephews or other family members, that those individuals need to have an interest in the individual with a disability, be willing to learn about the individual's needs, be available to make decisions. And that's really the important part. Be available to make decisions on behalf of the individual with special needs. It's obviously very helpful if the individual guardian lives close by to the person with special needs, what the law calls the ward. It's not the term I made up. It's sort of the antiquated term that the law uses. The person with a disability who's incapacitated is often referred to as, quote, the ward. But, we could just refer to that as the person with a disability. Obviously, it's helpful if the guardian lives close to the person with a disability, but it's certainly not required. We live in an increasingly small world between the phone and internet and mobile communication devices and so on. People are rarely out of touch anymore. I'm, for one, sadly, seem to never be out of touch, and I know I'm not alone in that. So really, the person who serves as guardian is going to be called on to make substituted decisions on behalf of the individual with a disability, so they just need to be available and be on call to make those decisions, and that really is the most important thing. If there are no other more distant family members to serve, then you might be looking at professionals or professional guardianship services. Whether it's the Bureau of Guardianship Services under the umbrella of the state of New Jersey, or nonprofit organizations like Plan New Jersey, or other community trust organizations that have the capability and the willingness to serve as guardian. Okay. So when should we begin the process of thinking about when should we start the process of guardianship? Really, it's kind of best to get the ball rolling. What I tell folks is let's get the ball rolling. Let's get together and get started about 4 to 6 months before the child's 18th birthday. Some people try to start this process much earlier than that because they get the impression, often from others who aren't maybe as well informed, or they start getting a lot of pressure from their local school district, or perhaps if your child's in a private school in an out-of-district placement, that school starts to remind you and put pressure on you to begin the process, at a much earlier age. Usually around 16 years old, school districts start, reminding you, or private schools start reminding you. You really can't begin the process officially until the kid turns 18 years old. You can't file in the courts until that time. And so it's a good idea to come in and get together and go over all this stuff about 4 to 6 months before the person's 18th birthday, so we can get the paperwork drafted and edited as necessary. We can get everything teed up and ready to go on or around that kid's 18th birthday. So once we get all the paperwork filled out, what are we doing here? We're submitting an application to the court, various legal pleadings and whatnot, in order to get a person declared incapacitated and to get that person appointed a guardian. There are a myriad of different documents that have to be drafted and submitted all at the same time. What's called a verified complaint, that's the main document that gets the ball rolling. It explains why a person is in need of a guardian. Hey Larry, how are you doing? Cleaning guys are here. so I'm still in the office and the cleaning guys just stopped by. Sorry about that. So we have the verified complaint, which explains why a person needs a guardian. We have to have certifications or affidavits from two physicians. They can be the child's pediatrician, they can be pediatricians in the same practice, it can be the pediatrician and neurologist or neurodevelopmental pediatrician or whatever it might be. But they have to be two doctors, either both MDs or an MD and a DO, and in some cases we can use a doctor and a New Jersey licensed psychologist who would submit certifications that generally I prepare, have a few blanks that need to be filled in by the healthcare professional, a psychologist, him or herself, and sign them and give them back to you as the parents. We have to submit various other documents called an affidavit of assets, a verification of pleadings, some notices that have to go out to various individuals, particularly if you have adult siblings of the child with a disability. They all have to be put on notice. If you're a divorced parent, you have to notify your former spouse, the parent of the child with a disability. Generally, in those cases, it's a good idea if you can get along to serve as co-guardians. Not necessarily the best idea to get involved in a contested guardianship between two divorced parents, because that just becomes a custody battle masquerading as a guardianship in a different part of the courthouse. And there are a bunch of different documents and different notices that have to be sent out along the way. But these are the main documents that get the whole process going, and they have to be filled out and submitted in a particular way, in a particular format, describing why the person is in need of a guardian. It's also important to know that the timing of things can be fairly tricky. Again, you can't submit the stuff to the court until the child's 18th birthday. And these two doctors that we talked about before, their certifications have to be completed and their examinations of the individual have to occur within 30 days of our applying or submitting everything to the court. So in other words, if we're going to submit if we're going to submit the thing to the court on June 30th, because that happens to be the child's 18th birthday, you cannot have the doctor's certifications be any time before June 1st. If they're done on May 31st, the court in most counties will kick it back, and they will not file the paperwork, even if they're one day at a time. Now, some counties are better than others. Some counties take a very hard and fast, rigid application of the rule. Some counties will give you a couple days leeway either way, but you're really anywhere in the state of New Jersey, if you're, very much out of time, the court will just simply send you your paperwork back, or send the paperwork back to us. Make you reschedule the appointments for the doctors, have the doctors submit the forms again, fill out the forms again, give them to you, and then we'll have to resubmit them to the court. And as you might imagine, is a real logistical pain in the neck or another region of the body. So once we get everything filed with the court, then what happens? So now we're sort of off to the races. We've launched. What happens next is the court will schedule a date for an in-person hearing, which in many counties here in New Jersey won't actually occur. In some it will, but in most counties there will not actually be a requirement for an in-person hearing in most uncontested guardianships. So the court will set down a date for a hearing, and the court will appoint a lawyer to represent your child. I don't when I'm handling a guardianship most of the time, unless I'm appointed by the court, I don't represent the child with a disability. I don't represent the person with autism. I represent his parents, or whoever it is you're seeking to become the guardian. I hope that you have had no reason in your lives to need lawyers, but when your kid turns 18, they start hovering like flies. So, I'm involved. Court appoints an attorney to represent your child. That person's job basically is to meet with your son or daughter, make sure that he is a living, breathing human being, make sure that from a layperson's point of view that person appears to be someone who's in need of a guardian, talk to mom and dad and make sure they don't have like 3 heads or somehow otherwise inappropriate to serve as guardian, and draft a brief report to the court summarizing his or her findings, the court-appointed attorney's findings. And probably 99.9% of the cases recommending that the person needs a guardian and that mom and dad should serve as guardian. As you might imagine, as the parents who are seeking application to become the guardian, the court will assign that attorney's fees. That attorney who represents your son or daughter is permitted to charge a fee in most counties. Those fees have to be approved by the court to be reasonable. And you, as the parent, are going to be responsible, unfortunately, for paying for them. They generally are not that oppressive. It's all relative, though. I mean, certainly there are better ways to spend your hard-earned money, I'm sure, than on your son's lawyer or your daughter's counsel. And fees can vary from county to county and part of the state. You know, in northern New Jersey, I guess that's a relative term too. I don't know where everybody's listening from. In northern New Jersey, I would say from, you know, I don't know, Somerset, Morris, Essex, north. You know, court-appointed counsel in a typical uncontested, you know, fairly obvious guardianship is going to probably charge a fee in those counties of anywhere between, I don't know, $1,500 to $2,000 for their time. But that's very, very ballpark. Could be a lot less, could be a little more. This is very ballpark. You know, in southern New Jersey, and by southern New Jersey I mean anywhere from, you know, Burlington, Camden, Ocean counties down, you know, counsel fees are going to be a little less because fees, attorneys' fees in general, tend to be a little less in that part of the state. In that part of the state, you're probably going to spend anywhere between, you know, 12, 15, maybe a little more on court-appointed counsel on average. You know, and in Central Jersey, you know, Middlesex to Burlington and so forth in that area, you know, the 732 and 908 area codes, you're probably going to spend somewhere in the middle of those two. These are really, really rough estimates, guys. And these are very big approximations and ballparks. But I know you're all out there saying, well, what is this usually going to cost me in terms of court-appointed counsel fees? So these are some rough estimates. And these are obviously based on experiential, my experiences in most places. And this is in, you know, 2013 terms. I know this is going to be preserved on various websites for some time, so if you're listening to this several years from now, you can bet that the fees are going to be higher in general. And as I said, those fees have to be approved by the judge who appoints the attorney for your son or daughter, and they're not due until after the whole process is over. My experience with most attorneys is that you can usually pay those fees off in a couple of chunks, and court-appointed counsel is happy to work with you with respect to those types of things in most cases. I have certainly seen fees a lot more than that, and I've certainly seen fees a lot less than that, and I've certainly seen attorneys devote a lot of time, and I've certainly seen attorneys in these roles devote very little time, you know, to these appointments. And of course, in a contested guardianship, which, you know, I handle every once in a while, you know, or I represent one parent over the other, you know, all bets are off because those are just very difficult types of cases. Once the judge gets court-appointed counsel's report and comes up to the date of the hearing, the judge will review all the information that's been submitted. You know, it's up to the judge in the particular county whether an appearance is going to actually be required. And in most cases, a judge isn't going to require a hearing. It will simply sign an order on the day that the hearing would have occurred. You know, he or she will sign the order in his or her chambers on the day the hearing would have occurred. You know, and voila, you're the guardian. Some counties do require an appearance, regardless of whether it's an obvious need for a guardian and regardless of whether everybody's in agreement that a guardianship is necessary. Those counties, at least these days, include Passaic County, always requires a court appearance. Essex County always requires a court appearance. Burlington County usually requires a court appearance. Other counties rarely, if ever, require a court appearance, like Monmouth or Bergen or Morris. So it can kind of vary widely depending on where you live and the individual preferences of the judge that we're talking about. Rarely, if ever, and really only in a couple of instances have I ever had this happen, rarely, if ever, does the child with special needs actually have to be present in court during the hearing. I've only had it happen a couple of times, once in Camden County, once in Essex County, and they were just really oddball kind of cases. And, you know, particular sensitivity was given in those cases. So this might be a good time to take a little bit of a break and see if there are any questions. Elena, do you have anything coming your way?
I do. I have a question from someone who states that their son is 18 years old, has cerebral palsy, and uses a wheelchair, and also has limited speech, so he uses a Dynavox for communication. However, he's smart and he is going to go to college. Her question is, does she need a guardian?
Mm-hmm. Well, I mean, I'm going to make certain assumptions in the answer of that question. Whether the person needs a guardian or not, I can't really say for sure, you know, particularly in a format like this. But let me just say, if that's so, with those sufficient disclaimers, as any good lawyer, let me say this: individuals with CP are, you know, every disability is unique from one another, and every person is unique from one another. A person with very profound intellectual and developmental disabilities as a result of Down syndrome, let's say, or an injury sustained at birth, and that individual has significantly diminished IQ, may very clearly to anyone need a guardian. Individuals with CP can vary quite widely. So some people with CP may have significant, quote, physical disabilities, as described there, limited mobility, limited speech, may need adaptive equipment, whether it's a wheelchair or augmentative communication device, in order to navigate the world, but have absolutely, positively no diminution in cognitive ability. And they are just as intelligent, if not more so, than anybody else out there. And they may be able to then therefore manage their affairs and govern themselves independently. Remember, that's the legal standard, whether they can manage their affairs and govern themselves independently, including whether they can direct others to do things for them. If the person has CP and also has significant cognitive limitations and is not able to articulate, even with communication devices and other equipment, and able to manage their affairs and direct others to do things at their behest, or enter into a contract, or make medical decisions, or provide informed consent to a medical procedure or whatever, then they may need a guardian. But if a person with CP can do all of those things, then no guardian is necessary, I would surmise. Just because you have a disability doesn't mean you need a guardian. But many people who have a guardian obviously have very significant disabilities that may include physical, but more importantly in this kind of discussion, it's more of an issue of what their cognitive limitations are, if any. So, Elena?
Okay, the next question, is it appropriate to request guardianship if the child is considered, quote, high functioning?
Mm-hmm. I think it's appropriate to consider a guardianship if the child is, quote, high functioning, and I assume that we're talking about, you know, given that this is a webinar to Autism New Jersey.
Mm-hmm.
Talk about a high functioning autism, Asperger's, etc. And yes, I do think it's appropriate to consider it. We're going to get into a concept of limited guardianship here in the next couple slides. But what I find is those individuals who are, quote, higher functioning often need a guardian as much as anyone else, because although they're able to handle to many degrees their own ADL skills, their own morning and evening routine, and they may be able to sort of make decisions about where to go and where to live and whom to associate with, or maybe even where to work. The question becomes are they going to be able to do those higher level skills? Are they going to be able to enter into a contract for something, to purchase an automobile? Are they going to be able to sign a lease and know what they're getting into? Are they going to be able to budget their monthly expenses? Or are they going to blow all of their money from work or Social Security benefits on video games or renting videos or whatever? Are they going to have the ability to plan for themselves, budget, stock their pantry with food, or are they going to sit around and watch YouTube videos all day unless someone reminds them to do that? Again, as I said before, put them in a world that doesn't exist, where they have no supports whatsoever. If they run into a problem, if they can medicate independently, because it's part of a routine, that's one thing. But if they run out of medicine in their bottle, are they going to know how to go about or be able to call up the pharmacy and get a refill? What happens when they call the pharmacy and the pharmacist tells them that they're out of refills? Are they going to be able to call the physician and have the doctor's office phone in more refills to the pharmacy? And what if the doctor's office says you have to come in for a checkup? Are they going to be able to schedule that and get there and do all of those things that are necessary to work around these kinds of problems? These higher level executive functioning problem solving skills that frequently can stop a person who's, quote, at the higher end of the spectrum, in their tracks, because it's not part of a scripted routine, or it's something that's more challenging for them and more abstract for them to address. So it's appropriate to consider it. Whether it's appropriate to actually go through with it is a different story. But those are some of the questions to ask yourself, and perhaps, when I sit down with families and I go over this kind of stuff, I can help the family look at it in an unvarnished way, and you have to find someone in your life that can help you do that too. Right. Elena?
Okay, yes. The next question is, what is the difference between a guardian and a trustee?
A trustee is a person who manages a trust, and we're going to talk about trusts, but that's the person who manages a trust, which holds the money. A guardian is the person who makes decisions on behalf of the individual, him or herself. So again, medical decisions, legal decisions, financial decisions, educational decisions. So the guardian manages the person for the most part, and the trustee manages the money. Now, to the extent that that an individual has money outside of trust, which is not very common, a guardian can also manage certain amounts of money, like Social Security benefits or other nominal sums of money, for the most part. But really, they've got the person, and the trustee's got the money. Now, the same person can be both. So, if you have a child with an autism spectrum disorder, and you've got one typically developing sibling, as everybody ages and parents die, it's not uncommon for the typically developing sibling to serve as both guardian and trustee. They're just wearing two different hats, doing two different jobs. So, okay. Elena?
Yeah, I have a couple more questions.
Sure, go ahead.
The next one is, their child is autistic and cannot drive or cook and has limited self-care, but they are in the low average range from an IQ perspective. The question is, would this be a case where the reviewer would be reluctant to agree with a guardianship?
Probably not. That's actually not that uncommon of a scenario. A person's IQ scores in the average to low average range of intelligence. But again, this is a functional type of analysis. Can the person manage their affairs or govern themselves independently is the legal test. It's not based on IQ. In fact, I've had situations over the course of my career where you perhaps have somebody at the superior range of intelligence. IQs in the 130s or 140s, and need a guardian, because although that person may have a superior range of intelligence, or superior intelligence, doesn't mean they can do anything for themselves in a practical sense when the rubber meets the road. And certainly in those instances where the IQs are so high, it certainly raises an eyebrow in the eyes of the court, or in the court-appointed attorney. But generally speaking, once a little bit of consideration is given, a little bit of review is given, and once we are able to demonstrate that that person is not really able to make decisions for him or herself or apply these superior intellectual skills in any practical way, it becomes readily apparent that the person needs a guardian. So, hope that answers that question.
Okay, it looks like I have just a couple more questions, and then I guess for time's sake for now, we'll go ahead and move on after that, and then we can, if anybody wants to continue typing in questions, that's fine, and then we can revisit some of the questions later on.
Sounds great.
Okay, so okay, the question is, can a family submit the documents for guardianship without an attorney?
They can, absolutely. There are actually kits that are available from the New Jersey Supreme Court, from their webpage, that you can Google and get to. And you can help. You can complete those forms and submit them. A word to the wise, or just a word of caution, I guess, is there are a lot of very picayune little rules that I glossed over or skipped over in my earlier comments about what has to be done, how you serve notice, and time frames for which you have to submit things to the court. Frankly, that I have a whole staff of people to do for me and to do for clients. You have to submit, you have to serve notice on certain people by regular and certified mail, and you've got to wait for green cards to come back, and then you've got to get green cards into the court within 5 days of the hearing, or the return date of the guardianship. And then if the post office loses the green card in the mail, then there are special certifications have to be filled out, or affidavits have to be filled out that says, I swear to God I mailed it. And these things can get pretty tricky, and the courts, they're not there to necessarily help you with this stuff. You're not necessarily going to be able to call the court clerk up and tell them and ask them, what should I do? They're not really going to tell you. And, to be honest with you, the first time I ever did a guardianship way back when, I completely screwed it up because I did not know all the procedures and all the timelines and all the little picayune hoops that you have to jump through. So, it took me a couple tries to get it right, and I was theoretically a fairly sophisticated, educated attorney who theoretically knew what he was doing. So you can muddle through it, and you can get through it, and you will get through it if you stick to it long enough. It's just, it's not going to be the fastest procedure you've ever done in your life, and it's probably going to be fraught with frustration. And my experience is if you mess something up, you're going to have to go back about 2 or 3 steps and start over again. So whether you choose to do it yourself or enlist the assistance of an attorney to help you with it is certainly your call, and there are certainly resources available online to allow you to do it yourself. And if you do, good luck. Elena, any other questions?
Well, I think we can move on for the moment.
More, right?
Let me just see. And this might be something that you're about to address, so I'll go ahead and ask it before we move on. The person wants to know the difference between guardianship and power of attorney.
We are going to get to that, so when I hold that's like about 2 slides away.
Okay, then we'll continue for now, and then there may be some questions that are still flowing in, and we'll be sure to go through those questions at our next break.
Yeah, we're going to take another little stop here in a few slides or whatever.
Great.
All right?
Okay, thanks.
All right. No problem. Thank you. All right, so moving on, look, the responsibilities of the guardian we've kind of touched on already, to make substituted decisions that are in the best interests of the individual who is the subject of the guardianship. When you make these decisions, you're not supposed to be making them in your own best interest or your own self-interest or the self-interest or best interest of another, but in the best interests of the individual who is incapacitated. Again, these are most commonly in legal, medical, and financial decisions in nature. Guardians are required to visit the individual who's the subject of the guardian a minimum of once a year, sometimes 4 times a year, at a minimum, if not more so. And guardians are supposed to take into consideration the individual's desires and preferences when making a decision. That doesn't mean you're bound by that individual's desires and preferences, but you're at least responsible to try to ascertain what those desires and preferences are. So if you're making a decision about where this individual should live, you should go ask the person, where do you want to live? Now, just because they express a preference doesn't mean that you're bound by it, as I said. So if the individual says, I want to live in a box under a bridge, and I don't want to live in this nice, warm, comfy home over here, you're not certainly bound by that. And matter of fact, if you were to let the person live in a box under a bridge, that probably isn't making a decision which is in the individual's best interests. But if the person says, I'd like to live in town A versus town B, or I'd like to live in this group home as opposed to that group home, or I'd like to live in this apartment over here as opposed to that group home over there, or I'd like to live with my sister if she's willing to take me as opposed to an apartment on my own, assuming the sister's willing to do that, you've got to take those preferences at least into consideration. If the preferences are unreasonable, you're certainly under no duty to follow through on them. You do want to then think about naming a successor guardian. Actually, let me come back to that one. I don't really like the word I put that slide. Let's do this one. I'll come back. There are alternatives to a guardianship, or sometimes called a plenary or a full guardianship. In a full guardianship, it's kind of what we've been talking about all this time. That's where the guardian gets to make decisions in all areas: legal, financial, medical, personal, where to live, where to work, who to associate with, etc. There are certainly alternatives or lesser forms of guardianship than a full or plenary guardianship. Slide says plenary because lawyers have to come up with fancy words for things that sound really good, but confuse the rest of the world. Plenary and full are the same thing. So there is concepts known as limited guardianships. Limited guardianship is a situation where the person asked before about person's higher functioning, or somewhat able to make their own decisions, or may have a higher IQ or whatever. That person may not need a full guardian. They might need a limited guardianship. That means the guardian's authority is limited to one or more domains, but not all domains of that individual's life. So it's really not uncommon for kids who become 18, who are quote-unquote higher functioning, to have a limited guardian, and the parents are able to make decisions with respect to medical decisions, let's say, or financial decisions, but all other domains are left with the now adult child. So probably the 3 most common is the guardians are able to make decisions about legal, financial, and medical. But personal decisions about where to live, where to work, whom to associate with, etc., remain with the now adult child, and he or she can make decisions on his or her own. So the court in those instances would carve out and leave certain rights and decision-making authorities with the incapacitated adult, but would let the parents or other guardian make decisions in all other areas. Depending on the particular needs of the child, it may be not all 3, but maybe 1 or 2 of the 3. That's obviously something you want to consider. But again, something to note there as a practical matter, the concept of a limited guardianship can be quite illusory. It can be kind of artificial in some ways. So let's say, by example, what I mean by that is, let's say that you as the parents are the guardian for purposes of legal, financial, and medical decision making, but all personal decisions remain with the now adult child. Is where to live a personal decision? You bet. Is the decision about whom to associate with a personal decision? Absolutely. Is the decision where to work a personal decision? No doubt about it. But is it also a legal decision? Absolutely. So you have a situation where the person is deciding where to live and they want to live on their own and are making that personal decision, but who's going to pay the rent? Who's going to sign the lease? These are things that the guardian can certainly control because they're able to control other very important aspects of that individual's life. Most importantly, the finances. So, a limited guardian can certainly exert significant power, and almost as much power as a full guardianship. I also want to take a moment to say that even in a full guardianship, the guardian's authority is not boundless. So the person still retains the right to vote, retains the right to marry, and maintains all of their hot-button, social rights, a lot of the reproductive rights, abortion, contraception, procreation, etc. They all, even if you have a full guardian, the guardian cannot consent to a tubal ligation or a vasectomy on behalf of the individual who's incapacitated. You need specific court authority to do that. As I said, a person retains the right to vote. Yes, incapacitated adults can vote, and I would be comfortable if, only people who are under guardianship maintain the right to vote to the exclusion of all others. I'm not sure that the Republic would be any worse off than it might be today. Other alternatives to guardianship in general as concepts of conservatorship or power of attorney. Now, power of attorney is a document that basically someone signs allowing somebody else to make the substitute decisions on their behalf if they are otherwise not available or incapacitated. So that's something that, is commonly done between spouses. So husband signs a power of attorney giving the wife authority to make decisions in his absence or if he's incapacitated with respect to financial and legal matters. A power of attorney is revocable, meaning it can be withdrawn or revoked. It can be signed in somebody else's favor, revoking the previous version. And just because you're the power of attorney doesn't give you rights to make decisions to the individual's exclusion. So if I sign a power of attorney in favor of my wife, she can make decisions for me if I'm unavailable or incapacitated, but that doesn't mean I've given up the authority to make decisions on my own. So if I'm not available, right, she can raid my 401k and sail off into the sunset. But if I'm incapacitated, she can manage my legal and financial affairs. But that doesn't mean I can't do the same thing if I am capacitated, even if she is my power of attorney. If my wife and I were ever get divorced, I would obviously withdraw that power of attorney. So if you have a kid who's 18, signs a power of attorney in favor of mom and dad, and then, when he's 22 years old and he's working and he's no longer at school and some cute girl at the job site he's working at and starts to whisper in his ear and manipulates him and gets him to sign things over to her, including perhaps a power of attorney, revokes the previous version, and there's nothing you can do about that. A guardianship is easily revoked. So certainly downsides to a power of attorney, and the upside obviously is it's something that's done privately. You don't have to have a judge approve these things, and it's just something that's a power of attorney is drawn up by an attorney, and and your son or daughter signs it, giving you authority to make decisions and when necessary or when appropriate. Another limitation or another drawback to a power of attorney is that you have a person who's clearly incapacitated or appears to be incapacitated in the mind of a neutral third party. You have to give consideration: is the person going to honor the power of attorney? So if you have a power of attorney or a medical directive that allows mom and dad to make medical decisions or legal decisions on behalf of the child, the now adult child, if the doctor looks at you and says, I know that you got a power of attorney here, and it's clearly, I believe that he signed it, and I believe he signed it voluntarily, but I don't believe he had the capacity to understand what he was signing. I'm not going to follow it. I'm not going to honor it. Whether the doctor is right or wrong, or whether the clerk at the bank is right or wrong, is not going to matter when they're not going to do what you want them to do, because they believe that the person didn't have the authority to sign the power of attorney in the first place. So a power of attorney is very appropriate in many circumstances, again, particularly when the person is higher functioning. Perhaps in the instance, again, I'm speculating about that question that was asked by the person who has a child with CP, who's, very smart. Power of attorney may be appropriate there, and a medical directive may be appropriate there, and a guardianship might not be. So, and a conservatorship is basically just a judicially approved arrangement that allows someone else to make financial decisions on behalf of another. And it is also voluntary. So if I'm aging and I may understand or realize that I'm not really able to handle my own finances anymore, pay my own bills and handle my own banking and so forth, and I need some assistance with that, I may actually ask the court, voluntarily ask the court to appoint maybe one of my adult children as my conservator to help me with my finances and my bills. It's basically just a judicially approved, almost financial power of attorney. So hopefully that answers the question about what's the difference between a power of attorney and a guardianship. Lastly, before moving on to wills and trusts, parents want to obviously think about whom they're going to name as a successor guardian after they die. It's a good idea to name a successor in your will, which leads nicely into the estate planning side of this discussion. The person who's named in the will, the successor, the backup to you guys as parents after you're gone, that's still a judge still needs to sign off on that, but the person who's nominated in the will is almost presumptively assumed to be the guardian. But there is some paperwork that's going to need to be filled out, and a judge is going to have to sign an order. But it's going to be a lot less complicated. And an alternative to that is parents age and typically developing children or adults and become more mature and more settled. It may be a good idea, to go back to court and have the now typically developing sibling appointed as co-guardians with mom and dad. Many of you may know, I know, some of you out there probably have seen or heard me before. I have an older brother with autism. When he turned 18, I was 15, going on 16, and obviously I wasn't old enough to serve as a co-guardian with my parents. Now that my parents are older, and I'm much older too, several years ago, probably about 10 or more years ago, went back to court and just had me added on as a co-guardian with my parents. So technically it's the three of us, and we all have co-equal authority. Now in reality, if you think I have as much authority as my parents, you're sadly mistaken, and my mom is very clear about that if I were to ever do anything without her knowledge or approval, she would kill me. And and like any good adult child, I'm as much afraid as my mom as I was when I was a child. So I'm not going to certainly disobey that. But it is obviously a good thing to consider doing, because parents die, they die suddenly, or they become incapacitated due to their own advanced age, Alzheimer's, dementia, or whatever, or perhaps more happily, they're just out touring the world, and they're unavailable, and a decision needs to be made. The typically developing sibling can step in their absence or their parents' own incapacity and make decisions for their brother or sister. So,
Paul, if you don't mind, there is one question that will probably be just in that transition now that you're going into will. So if you don't mind, sure. I can ask the one outstanding question.
Not at all.
Okay. the question is, if I decide to choose my brother to be the trustee and guardian for my child, how much is the standard fee for a non-professional trustee or guardian? So I guess for a family member to be the trustee or guardian, what they're asking what the fee would be for that.
What the fee?
Yes.
Yeah, it's a good question. There are the term you're searching for is a commission. Guardians are permitted to take a commission, and trustees are permitted to take a commission. So a guardian's commission is set by law at 6% of the income that the individual who's under guardianship has. So 6% of the Social Security check, or 6% of earnings from work, or whatever. And by and large, no one's going to get rich off of being someone's guardian of an incapacitated adult with an autism spectrum disorder, more likely than not. And my experience is that very few people actually take the guardian's commission, although I always advise that they should, because at a minimum it helps reimburse them, the typically developing child or other guardian for some expenses and whatnot. The trustees' commission, again, are set by law, although the trust agreement can alter that. So again, by law, by rule, trustees' commission is also 6% of the income earned by the trust. So if there's interest income earned on the principal in the trust, you can take 6% of that as the income, and then under certain circumstances, you can also take what are called corpus commissions, or a small fraction of a percent of the principal of the trust as commissions. Again, my experience is even in larger trusts, no one's going to get rich off of that either. And oftentimes, the family member doesn't take that commission, although I always encourage them to do so for the same reason. There are alternate fee strategies that can be set up, and sometimes in the specialties, usually in the specialties trusts that I draft, I just usually recommend a straight, slightly enhanced income commission with no corpus commission, so we don't nibble away at the principal in the trust. So, all right. Hope that answers that question.
And there is actually one question outstanding that I just noticed that would also kind of fit into this area. The person is asking if they do not have anyone as a successor guardian, what would happen after they die?
Well, assuming, this assumes that mom and dad are the guardian or whatever, and they die, and they don't name anybody as successor to themselves, or there isn't anybody, the court's going to appoint somebody. You can't have a vacuum. If you have a guardian, you can't have that office go unfilled. So the court will have to appoint someone, and that may appoint a professional guardian. It may appoint a lawyer who would serve as guardian. Which probably really wouldn't be the best thing in the world would not be the best thing in the world to have happen. And they may appoint an organization like Planned New Jersey. They might appoint whatever family member, if any, would step forward. And the family member that steps forward may not be the family member that you would ever want to serve as guardian. So my advice is it would be a good idea to prepare for those things in advance. And if you don't have any family in your life that could or you're willing to have serve in that capacity, you're probably better off investigating what the professional guardians might be, and interview them, and gauge your comfort with them before you do die, and appoint them a successor to yourselves to take over upon your death, because at least you get some level of control and some decision-making authority in who's going to make these important decisions for your son or daughter, after you're gone. So.
Okay, I think we're ready to move on.
Move on? Okay,
yes.
Great.
Okay,
so now we talked about guardianship and passing that over, so now we're talking about the very uplifting topic of, death and estate planning. So Nothing in this world is certain but death and taxes, as they say, and here it is all wrapped up in one. So look, I get people in my office all the time, and they are concerned about what will happen if they die, and it's not a matter of if, it's a matter of when, guys. Sorry to tell you. None of us are immortal, as a client of mine once said, and I thought that's a little bit more poetic. If you have a kid, look, if you have a kid with a disability, or if you don't have a kid with a disability, estate planning, wills, trusts, and succession planning is vitally important for a variety of reasons. For taxes and the minimization of the impact of estate taxes upon your death, which we're not going to get into this evening, but just know, an important part of overall estate planning is to minimize your tax liability. But, and by the way, you don't have to be rich to have to worry about the estate tax. So you don't have to have a lot of money upon your death in order to get caught up in the estate tax net. And people are always worth more dead than alive, because you don't think about insurances and 401ks and the value of your home and the equity in your home and stuff like that as being money, because you don't really have the ability to access it during your lifetime, but it becomes part of your taxable estate. So I don't care who you are, or where you live, or how much money you got, or what kind of a job you have, or how much money you make on an annual basis, you do need to worry about the impact of the estate tax upon your death, because the less you pay in taxes, the more goes to your kid or kids, and including your kid with special needs. So it's important from a tax point of view. It's important for a succession planning point of view. Who's going to serve as backup guardian, and who's going to make decisions on behalf of your son or daughter, or your typically developing minor children after you die, if you were to die prematurely, and whatnot. And it also, is important for determining where your stuff goes and who's going to get your stuff after you're gone. A typical estate plan for a family who has a child with on the autism spectrum will include, what I call some cornerstone documents: wills, durable powers of attorney, living wills, special needs trusts, at a minimum. All right, and then in some instances, depending on the tax impact, that you may have to get into things like credit shelter trusts or irrevocable life insurance trusts in order to minimize or avoid the impact of the federal or, and more importantly, the state of New Jersey's estate tax, because New Jersey does have an estate tax as well. So those are sort of the basic cornerstone documents, and probably 80 to 90% of the families out there. Look, the will becomes an important document. That's basically the basic cornerstone document, is the will. There's no such thing as a simple will. Some wills are more complex than others, but a simple will is a misnomer. Wills are just wills. Wills just say who's going to do some important work when I die. It tells you where the money is going to go when you die, who's going to do what job, who's going to be named the guardian of your non-disabled minor children, or your who's going to be the guardian of your adult child with special needs. So, that's what a will does. It provides for the orderly transfer of your assets and your affairs to another person by someone. So most wills say give everything to my spouse, and then give my stuff to my kids. And the person who does all of that for you is called an executor, and they have the unenviable job of going through all your stuff, pulling the dumpster up to your front door and throwing out all the junk that no one wants, making the claims for your life insurance policies, filing the necessary paperwork with the 401k, submitting your will to probate, filing your estate tax return or your final income tax return, and passing out the money to whoever's supposed to get it. And if they do their job right, they should be done in about 9 months to a year. Sometimes less, sometimes more, but that's the person who does that, and that's what the will accomplishes. All right. Another basic cornerstone document is the durable power of attorney. allow someone else to make decisions on your behalf if you're incapacitated. We talked about this before as an alternate to guardianship. An agent under a power of attorney handles, well, let me back up. The executor handles your legal and financial matters and so forth upon your death, right? The agent under the power of attorney, while you're incapacitated, handles your legal and financial affairs while you're lingering on the threshold of death, right? And they do all that stuff, and then when you cross over the threshold of death into death, right, the executor takes over. So, oftentimes the agent under your power of attorney may be the same person who's the executor. Sometimes it might be a different person, but those are sort of the distinction between the two. While you're incapacitated before you die, executor takes over after you die. It's important, for families who have a child with special needs, and you're not going to see this in your run-of-the-mill durable power of attorney document, but there should be a provision for who would be a temporary guardian in the event of your incapacity. And that's something that's often overlooked. So, if you name a successor guardian to yourselves in your will to take over after you die, I mean, that's great, and that's really important, and that should be done. But what happens while you're incapacitated, Alzheimer's, dementia, automobile accident, traumatic brain injury, and you really are incapacitated, and you can no longer serve as guardian, but you're not dead. So executor or the successor guardian can't serve as guardian until you actually die, and it may take you 4 or 5 months to die. So you should probably talk in your power of attorney about a temporary delegation of guardianship during your capacity. And when I do special needs planning for families, I make sure to always include that kind of provision in the durable power of attorney document. Now, a durable power of attorney generally deals with just legal and financial matters while you're incapacitated. So handling your business affairs, your personal affairs, manage your money, invest your 401k, defend lawsuits, initiate and prosecute lawsuits on your behalf, appear before tribunals, change your residence, often appropriate or necessary if you're going to require a nursing home, change your residence to a nursing home, engage in Medicaid planning so that if you need to qualify for Medicaid long-term care, perhaps you can do that, make gifts, particularly make gifts to special needs trusts for the benefit of a disabled child, all that kind of stuff. That's what the durable power of attorney does. It has nothing to do with medical affairs yet. That's a separate document, often referred to as a living will. Sometimes called an advanced health care directive, sometimes called a medical directive, kind of all means the same thing. Like a power of attorney, this allows somebody else to make health care decisions, medical decisions on your behalf in the event you're incapacitated and can't make medical decisions on your own. So you're incapacitated and you can't communicate your medical intentions. An agent under your living will can consent to tests, consent to surgery or not, change your hospital, direct your health care, manage your health care insurance, etc. And including, if you give them the authority to do so, have the ability to make medical decisions with respect to life-sustaining treatment, pull the plug type stuff. And that has to be specifically written into the document. And although not binding and has no independent legal authority, again, you probably want to use this this document to at least express some information regarding your health care decisions or preferences or aspirations for your child with a disability. While you can put these kind of things down in a letter of intent, it is not always a bad idea to say something like, look, if I want my plug, if I have a document that allows someone else to make decisions for me, that allows them to pull the plug, I could foresee circumstances where I'd want my child with special needs to not linger and suffer needlessly, and I would consent to having his plug pulled, as well. This might provide some important comfort to decision makers who are going to be left behind that may someday have to make this decision on behalf of your child with special needs. Provide some guidance and instructions that are hopefully live beyond the grave, so to speak, and can provide some assurances to those who will be left behind. And again, I try to include, whenever appropriate, I try to include language like that in documents as well. And then, of course, the big one when it comes to special needs planning and for families who have children on the autism spectrum or a disability of any kind, the special needs trust. And we're going to spend the balance of our time talking about that. So, a special needs trust, when you have a child with developmental disabilities or have a child who's not able to manage his affairs or govern himself independently, you're going to rely upon government assistance benefits, you're going to want to establish a special needs trust. Hopefully all of you know, if you don't, please if you don't take anything away from this webinar other than this, remember that a child with special needs, in order to maintain eligibility for very important, vital government assistance benefits, can, generally speaking, have no more than $2,000 in assets in his or her own name. There are some exceptions to that rule, but they are not all that common. And speaking in generalities, $2,000 is the cutoff. You definitely want to keep your kid's assets below $2,000. To the extent that you have assets in your child's name, and your child is under the age of 18, and particularly if your child is very young, you're going to want to get rid of those assets now. And you're going to want to make sure that you tell other family members who may be very well intended, please do not give any more money to my child with autism because he can't have assets in his or her own name. These are things like the bonds that are given at birth and birthdays and religious ceremonies and so on. These momentous occasions in a family's life. Gifts from grandparents, uniform gift to minors or uniform trust to minors accounts that grandma and grandpa set up, 529 accounts set up by grandma and grandpa, that kind of stuff. The well-intended relative will, and they're almost always given by family members, and the well-intended relatives will screw things up every time. It's almost assured. But you've got to be blunt, and you got to be polite but insistent. Please do not give any money to my kid because he can't have it. And if they won't listen to you, tell them, look, if you give the money to him, what's going to happen is the government's going to take it, and that usually does shut him up. SSI, Social Security, Medicaid, they're all incredibly vital government assistance benefits that your child is likely going to rely upon as an adult. And if your kid has more than $2,000 in assets in his own name or inherits more than $2,000 from you or from another family member who didn't plan appropriately, your kid is going to either not be eligible for benefits or lose his benefits. Plan appropriately and be insistent. The problem becomes, let's say that I'm a parent of a child with special needs and I die without a will, and I've got a house that may be worth $250,000. I've got 401k that has a balance of another $250,000 in it. I may have some life insurance that I held on to all these years, and it's got a death benefit of $500,000, and I've got $1,500 in cash in my checking account just to pay my bills, and I die. All right. You think about the $1,500 in cash because that's what you feel is tangible, but you forget about the equity in your home and your life insurance and your 401k. And if I die without a will and I only have one kid with special needs, that kid has just inherited $1 million, slightly more than the $2,000 asset limit that he's allowed to have. And if he's been on Medicaid for the last 20, 30, 40 years, and let's say he's been in a typical group home that's operated by a provider agency and funded by DDD and Medicaid for the last 20 years, or let's say he's been receiving self-directed services through DDD for the last 20, 25 years, which is also a Medicaid-funded program. What happens is DDD and Medicaid, they keep a running tab, a meter going on every dollar they spend on my kid over the course of his lifetime. You know, if he inherits the money that I just described, you know, the approximately $1 million that I forgot I even had because I didn't really think about it, when he loses his benefits, he loses his self-directed services, he loses his payment for his group home, and I've just created a big mess. Now, the government can come in and exercise its lien and pay itself back at any time, and you know, the lien may be over $1 million at the time of my death, and the government may come in and grab the money to satisfy its lien. The good news is my kid is eligible for benefits again, and the bad news is I've just given a very large gift to the government, and my kid has nothing again. And meanwhile, others are running around like mad trying to reestablish Medicaid eligibility so that funding can continue. Many of you may have heard, and we have done other webinars on this, and I think we plan to do another webinar on this in the very near future. You may have heard that when it comes to adult services here in the state of New Jersey, that DDD is relying now more than ever upon Medicaid to help fund the cost of these programs. And DDD has, as of January 2013, has very clearly said that in order to continue to receive services from DDD, you have to be Medicaid eligible and or make yourself Medicaid eligible whenever possible. Now, we think there's some exceptions to this rule, and we think that these bright line rules are probably not as legitimate or as easily enforceable as DDD might let you think they are. But the reality is that it is clear, and it is the sort of the wave of the future, that in order to continue to receive services, and certainly in order to ensure the continuous receipt of uninterrupted services, you're going to want to obtain and maintain Medicaid eligibility at all costs. And this is one of the very simple things you can do to avoid a problem. And again, as I just described, avoid giving a very large gift to the government. So in these instances, when you have families who have children with special needs, generally we have a will that we discussed before, perhaps some other estate tax planning documents that basically say that upon mom and dad's death, you know, we give the money to the kids, and that share, which would otherwise go to my child with special needs, will instead be paid over to a special needs trust. And the special needs trust then holds the value of that child's inheritance after I die. So let's say in my previous example I die, and let's say I did have a will, and the will said give everything to my child's special needs trust. Now my kid then has $1 million in trust for his benefit, maintains his eligibility for Social Security, SSI, Medicaid, and other what we call means-tested government assistance benefits. And I keep the money out of the government's hands. I'm not obligated to pay the government's lien back either upon my death or my child's death. And I now have a pool of money to act as a safety net to fill in the gap and provide those things that my son or daughter needs after I'm gone. So it becomes very, very important to set this stuff up while you're alive and have it teed up and ready to go upon your death. So really, what is a trust? A lot of people have a misconception of what a trust is. They think it's an account at a bank or some fancy marble exterior, mahogany interior financial institution. It's some mysterious, amorphous thing, a trust. A trust really isn't all that mysterious, guys. And it really is not something to be intimidated about. A trust is nothing more than a piece of paper with words on it. That's it. A A trust is created by a trust agreement. It's drafted by some lawyer somewhere. If it's drafted properly, a special needs trust has to contain some very important and technical language, and it should give the family who's left behind or the trustee who's left behind some flexibility on how to use the money and some instructions on how to use the money for your child with special needs. But it's nothing more than a fat piece of paper, with words on it that describes how the money is supposed to be used. Once the parent signs the trust agreement, a trust is created. So trusts generally have their own name. They have their own tax ID number. It's almost, think of it like a business entity, or it becomes a fictitious person. The trust has its name. It might be the Smith Family Special Needs Trust of 2013. It has its tax ID number issued by the IRS. And a trust then can open up one or more accounts or financial instruments in the name of the trust. So if I have a special needs trust called the Smith Family Trust of 2013, that trust might have a bank account, just a general passbook savings or checking account with $10,000 in it. It might have a mutual fund which has $100,000 in it. It might own a piece of real estate like a house or a condo that my child with special needs can live in. And the deed to that house or that condo or whatever is titled in the name of the Smith Family Trust of 2013. A trust can own anything you or I can own. It's just that the asset or the financial instrument is titled in the name of the trust. A trust has three main actors, called a settlor, or sometimes called a grantor, a trustee, and a beneficiary. Now again, in keeping with the general principles that lawyers like to come up with fancy names for things that aren't self-intuitive just to confuse the general public, it really isn't that complicated. A settlor or a grantor is the person who signs the trust agreement. The parents, really. And in my example earlier, it would be me. I sign a trust agreement, I'm the settlor, I sign the document, I'm done. I've created a trust. The beneficiary is the person whom the money is supposed to be used on for the benefit of my child with special needs. So my son or daughter is the beneficiary. And the trustee is the person who manages the money, invests the money, and spends the money on behalf of my child with special needs. And that might be my typically developing son or daughter, or other family member or financial institution. You can have more than one trustee, could serve as co-trustees, kind of like co-guardians. The guardian and the trustee can be the same person, although it doesn't have to be, but it certainly can be. You can have a family member and a financial institution like a bank or a trust company serve as trustee together. And one might make decisions on how to spend the money, and the financial institution might make decisions on how to invest the money. And that is particularly useful perhaps if you have family members who are very loving and caring but may not be very good with money management and investment. So you may divide those roles if appropriate. But the person who does all of that, or the people who do all of that, is called the trustee. Now a special needs trust does have to contain some very important language that allows the trustee to use the money on behalf of my child with special needs, but not in a way that jeopardizes government assistance benefits. So a special needs trust can be used to pay for anything the kid needs as long as those goods, items, or services are not provided by the government. So if something is provided by the government, the trust can't pay for it. So you can't replace what the government is already giving you. But if the government doesn't pay for it, or if you want to make what the government gives you better or enhance the quality of what is provided through government assistance benefits, then the trustee can do that, is permitted to go ahead and use the money in the trust to enhance or pay for those things the government doesn't provide. So as I mentioned earlier, look, I have an older brother with autism who lives in a typical suburban-based group home. He's been there for a number of years, probably, close to 20 years now. And, through government assistance benefits, DDD and the like, he has most of his basic needs covered of, shelter and, basic food and and whatnot, for which we are obviously very grateful. And he's in a very good quality program. He's got a better social life than I do. He's probably out doing something right now that's fun, and I'm sitting here in my office all by myself talking to my computer. And so, obviously I wouldn't trade places with him at all. But he goes out to the movies, he goes out to dinner with his housemates. He goes to LBI in the summer, for a week every summer. He's been on a couple of Caribbean cruises with his housemates. He's got a very rich and robust life within the limits of his disability. Now, those things I just described, like the cruises and the LBI trips and whatnot, those aren't covered by government assistance benefits. My parents are fortunately able to make funds available for his use and enjoyment to allow him to engage in those experiences. But after they're gone, after they die, a trust will be funded for his benefit, which will allow me, as the trustee, to use the money to continue to let him have those opportunities and experiences. I'm the one who will be supplementing what the government gives, not paying for the group home, not paying for the staff, not paying for the basics, but will be paying for the supplementals, the fun stuff, the trips, the excursions, the vacations, the meals out, bowling and movies and all of that good stuff that, just aren't included in the government assistance benefits that are provided. And although the government assistance benefits that are provided are obviously substantial. If he needs something that's more medical in nature that's not covered, alternate medical treatment, professional second opinions that aren't going to be covered by insurances or government assistance benefits, I can obviously use the money in the trust to provide for those things that he may need. If his mattress wears out, and the state only budgets, $50 for a new mattress, and it might cost $500. I may be able to use $450 out of the trust to buy the better, more appropriate orthopedic mattress to meet his needs. Durable medical equipment as he ages, allowing him to age in place that isn't maybe going to be covered by the government, I can provide out of the trust. Again, supplementing or enhancing what the government gives, but not replacing what the government gives. And then lastly, what you want to think about when you're creating a special needs trust for your child is what will happen if there's money left over after your son or daughter dies. Because just as I said before, you're not going to live forever, neither is your child with special needs, and this may be 60, 70 years from now and your child dies, and there might be money left over in the trust. You get to decide as the parent who creates this trust where that money goes. Maybe that goes to your other typically developing children, if living, and if not, maybe their children, your grandchildren. Perhaps it goes to other more distant family members. Perhaps it goes to charity, to the provider agency that provided day-to-day custodial care for your child for his life, to Autism New Jersey, in support of its mission, allowing you to continue to further the mission of Autism New Jersey through its Evergreen Society, so that educational opportunities and advocacy can continue. And certainly I think the organization would appreciate that and thank you for it very much. Or a combination of all of those things, some to family, some to charity, some to the provider agency. I mean, you name it. The point is that you get to decide where the money goes ultimately after your son or daughter's gone, if there's any money left over. So that's all that you need to know about special needs trusts and estate planning and guardianship. And with that, Elena, if there's any questions, why don't you fire away?
Okay. I'm just looking through. We do have several questions, and since we're already over our time, I will try to address some that would be maybe applicable to a larger group. And I'll preface that by saying that I did post in, I don't know if everybody could see the chat section, we do have a couple of prior recorded webinars on the website, and they're also available at the Hinkle, Fingles, and Prior website. Accessing Adult Services is on our website, as well as Medicaid, SSI, and other entitlements. So if your question is more in those arenas, I would ask you to check those out, and also be aware that those webinars are also coming up again, and you can register for them on our events page. So that being said, the next question that I had was, let me just go back to it. I lost it. Okay. The question is, if they were to move to another state, would all of the estate plan documents created in New Jersey still be enforceable?
Short answer is yes, for sure, but you definitely want to have them re-examined if you move. Not for any other reason as there's going to be new estate or different estate tax issues. Many states have an estate tax, and some probate fees can be radically different in other states. So if you move from Jersey to Florida, let's say, you're definitely going to have different tax consequences. And if you move from Jersey to New York, let's say, you're going to have very different probate experiences, or particularly in western jurisdictions, west of the Mississippi, you're going to have very different issues there as well. So they're enforceable, but you're going to want to have them looked at again by a local special needs attorney in that state, not for any other reason but to deal with the tax issue. So.
Okay. All right. And just to reiterate to anyone who may have missed it at the beginning, just as with the other webinars that are recorded and available on both of our websites, this webinar will also be available for you to view and listen to. And we expect to have it up on our website within the week, and then, of course, Paul, you will know when that's going to be happening on your website.
Probably shortly after yours.
Yes. So don't despair if you missed any of the beginning of it. Okay. Let's see. I'm sorry. I'm just scrolling through a few questions. So okay. Bear with me for just a second. The window that I have to look at the questions is very small. Okay, it's really tiny. The question, though, from another individual is, how do you provide for your child if you are not financially comfortable?
Well, okay, that's a very relative term. And again, as I said before, you're always worth more dead than alive. I mean, people always assume that they don't have a lot of money, and they're not all that financially comfortable. People always forget about life insurance that they have through their employer or private life insurance. And I'm a lawyer. I'm not a financial planner, so maybe that's a question that's best left to someone else. But I mean, basically, one of the quickest, easiest, best ways in order to create a pool of money for your child's special needs is to make sure that you have life insurance needs addressed. Term life insurance, as long as you're in reasonably good health, will certainly provide, in many cases affordable, and will certainly provide a pot of money to your child's special needs after you're gone. Permanent life insurance or universal life insurance is even more preferable, but that's a quick and dirty and in many instances inexpensive way, relatively speaking, to provide some fundamental safety net after you're gone. But I also want to stress again, it can be very easy to forget what your assets are, and estate planning and special needs planning needs to be addressed by everyone. This is not something for just the comfortable or the wealthy or whatever. It's important for everybody. Aletta?
Okay. One last question. It's pretty specific, but I think you'll be able to answer it.
Sure.
It says, my husband and I have rental condos, so if we both die at the same time and my brother is the trustee for our child, does my brother get 6% of each rental income for managing the rental condos plus 6% commission for managing my child's needs?
That really wasn't that easy. You got to give me a better one.
Well,
you got to give me a better one to end on. But no,
okay.
no. I mean,
give you a doozy at the end.
to this question, I mean, it depends. How's that for a good lawyer answer? You know, it depends on whether the rental income is going to be managed by anyone after you die. I mean, that presumes that the condo isn't going to be sold, or the condos aren't going to be sold, and the cash is just going to be taken from the proceeds of the sale, and distributed among the children, including the special needs trust. If the condos are going into the trust, the income that they generate, you know, so if the title to the condo is going to be held by the trust in the name of the trust, that becomes a property of the trust, and the rental income becomes part of the income generated by the trust, so it becomes part of the 6% commission.
Okay,
that's about as good as I can get.
Well, thank you, and that actually is the end of the question. So okay. I'll just say one more time, we will be doing all of the 3 webinars that we've done are all coming around again. You can check those out on the link that I posted in the chat area on the Autism New Jersey website. So you can sign up for any and all of them, or you can always go back and listen to our pre-recorded webinars whenever it's convenient for you. And Paul, I'd like to thank you again for your generous time this evening. And
well, thank you.
If anybody has any questions, direct them to, you can direct them to me. My name is actually Elena. I know it says I'm Amy, but you can direct it to information@autismnj.org, and I'll just type that in real quick. If you have any follow-up questions about looking at the webinars or registering for anything, or just any other information and advocacy questions that you might have. And good night to everyone.
Thank you all again. Good luck.
Thanks, Paul.
Take care.